Okay, so talking about patents, as you may know, the general provision of the Brazilian IP law is that any invention that contains the requirements of novelty, inventive step, and the application are patentable. However, there are some relevant eligibility exemptions on the Brazilian IP law and we have some recent developments regarding the PTO's interpretation of these exemptions that are quite relevant for biotechnology involving transgenic plants and gene-edited plants that I will talk a little bit about. So the eligibility exemptions are provided in Articles 10 and 18 of the Brazilian IP law. Article 10 contains exemptions for basically natural things, natural products and processes and biological processes. So all the exemptions are limited to those that occur in nature. What is relevant is that unlike in Europe, for instance, I guess you're not yet seeing it. I hope that you can see my screen now. Okay. So as I was talking about Article 10, sorry about that. I hope that you can see now the presentation. Article 10 contains exemptions for naturally occurring products, including living beings and parts, biological material, as well as natural biological process. But the Brazilian IP law also contains another exemption on Article 18 for living beings, except with the exemption of transgenic microorganisms, which are defined in the Article 18 itself. There is a sole paragraph defining these microorganisms, and this definition specifically mentions that it excludes plants and animals. So, in a very brief comparison between the IP law and the TRIPS agreement, which the Brazilian IP law is an internationalization of, we can see that a case could be made that the Brazilian IP law even goes beyond what TRIPS agreement would allow exclusion of when Article 18 allows the exemption of patentability of parts of living beings, since this is not specifically provided in the TRIPS agreement. Another comparison that's useful to make between the Article 18 and the European Patent Convention is that whereas the European Patent Convention contains an exemption for plant and animal varieties, Article 18 of the Brazilian IP law is broader because it simply mentions living beings, and these are defined as except microorganisms, so including plants, animals, and any parts thereof, such as cells. There has always been these questions regarding what are the limits of these provisions. Just to sum it up, Article 18 has no limitation to naturally occurring matter, only to living beings in general, including basically plants and animals. Has no limitation to varieties, exclude plant parts, and provides its own definition of what is transgenic. That is not the standard definition by most scientific literature. So this has always been a question for the practitioners in the area, but as examination and even post-grant enforcement actions and nullity actions involving transgenic plants began to occur, the Brazilian PTO had to delve deeper into these provisions. So I will talk a little bit about the development of transgenic plants and how patent applications are filed and prosecuted, whereas these inventions are developed, because this is the main technological field that has provoked the PTO to issue new rules. So very briefly, as many of you may know, transgenic plants are developed usually identifying a gene from other species, usually bacteria, that has some trait of interest. If the gene can be expressed in a plant, this gene is isolated from the bacteria. A lot of work has to go into making this gene useful for expression in a plant, including codon optimization. A whole DNA construct has to be developed so that the protein can be correctly expressed in a plant. Promoter sequences have to be developed, and other gene regulatory elements must be present. And obviously, each one of these may be an invention on itself, but as a very general overview, there is usually a first patent application that is filed when the gene is identified. And another patent application is filed when this gene is finally inserted in a commercial plant to be expressed. So when this happens, as you may know, most plant transformation techniques do not allow for direction of where the insert is located in the genome. It involves a lot of trial and error, and many transformation events must be developed and then screened. And so a second patent application is filed for the transgenic event itself, which is usually called elite event because it's screened for the elite features and traits for the transgene. So what's relevant for examination of patent applications is that because of the timeline, usually the first patent application is prior art for the second. So in the second patent application, the gene itself, the construct, and the protein expressed are not usually, cannot usually be claimed because they are already parts of the prior art. So very briefly, the claims of the first patent application would be directed to the either recombinant or non-recombinant protein, the polypeptide, the DNA, including the gene, constructs, and so on, the transgenic plants, methods of producing the plants, crossing the plants, and its uses. On the elite event application, the so-called second patent application, most claims are usually directed to the DNA molecule or polynucleotide that is unique because of the unique sequences produced by this insertion into the plant's genome, the transgenic plant comprising this DNA, and also the method of producing, crossing these plants, as well as embodiments related to detection of the transgene and the event in the plants. So the Brazilian PTO has several rules regarding the eligibility exemptions that I mentioned before. First rules were issued on 2002. These were replaced in 2015, and then again the biotech guidelines was published in 2020. This is currently in force and contains some interpretations of what these eligibility exemptions mean for patent examiners. And it's important to bear in mind that whereas the PTO's rules are not law, the examiners are bound to these rules, so they must follow these rules when examining patent applications by the PTO. And finally, the most recent developments have been the issuance of technical notes that have been developed specifically for the assessment of these elite events applications. I will mention more detail moving forward. So just a very brief historical overview. Ever since the Brazilian issued first rules regarding assessment of polynucleotides and polypeptides, they have been deemed chemical compounds. This is the provision of now revoked originally examination guidelines. And because the Article 10 also exempts isolated biological material, the Brazilian PTO interpreted that it's necessary to have a structural difference. The claim must define a structural difference in order to exclude naturally occurring material. It's not enough to be isolated. because this is also exempted from the Brazilian IP law. The most recent rules are generally in line. They have a very similar interpretation. What has been made, what has added to this interpretation is that post-filing documents can be used by examiners to show that some claim matter occurs in nature, but it's the examiner's burden to provide these rules. So an objection under Article 10 regarding natural biological material cannot be generally raised without pointing to a document that shows that matter occurs in nature. And also, regarding the biological methods, the PTO has provided in its recent rules that since Article 18 does not contain exemptions to processes, then processes involving transgenic plants that do not occur in nature are not covered by any of the eligibility exemptions. So they are patentable. So as long as the resulting plant has a difference in its genetic composition, then there is no eligibility exemption to this matter. So to go back to the claims of the first and second patent application that I mentioned, in Brazil, what we have under the PTO's rules is that a protein, if structurally different from naturally occurring protein, is eligible. Same thing for the DNA, construct, gene, and so on. A plant is not eligible because of Article 18, and methods of production, crossing, and using transgenic plants are eligible. When we go to the second patent application, meaning the elite event applications, the main controversy was whether a DNA molecule or polynucleotide comprising parts of the plant genome would be a plant part and thus exempted from patentability. So the many examiners had one point, whereas other examiners had others, and as time went by and several cases were discussed, the PTO was seeing conflicting understandings. However, it was already clear that methods of production of plants, crossing, as well as the embodiments related to detection of the event were eligible, and also that the plant itself was not eligible under Article 18. So the only provision of the PTO's rules regarding what is a plant part were quite general. Basically, that parts include organs, tissues, and cells. It did not go beyond that. And biological materials were also deemed to encompass whole or part, but more explicitly provided it would go beyond tissues and cells, including extracts, lipids, carbohydrates, DNA, and so on. So there was already some hint that these things are different, but as I mentioned, examiners were still conflicting between each other. There was a different position among several examiners. So as I mentioned, as these patents and applications became important, many corrections were filed, both pre and post-grant oppositions before the PTO were filed. So the PTO felt the need to have more harmonized rules regarding these provisions. So the main question that the PTO faced was basically, to sum it up, what is a plant part? Or put in another way, what are the limits of the eligibility exemption on Article 18? So the first piece of rule that the PTO issued was called Technical Note 1 from 2022, wherein the PTO performed a combined reading of Articles 10 and 18, and noted that since Article 10 contains a provision for even if isolated therefrom, whereas 18 did not contain this provision, then the PTO provided that the term isolated would be enough to overcome the issues regarding Article 18. So they contain this, so they issued this rule without performing a public consultation, requiring that the DNA claims contain this term isolated. So as I mentioned, this was issued without public consultation, and many interest parties were concerned and had several doubts regarding these new rules. So for instance, it was, as I mentioned, isolated in Brazil has a different meaning, for instance, as in Europe, which is usually mean outside of natural context. In Brazil here, isolated would mean outside of the plant or plant cell, which would then mean that the DNA would be patentable as long as outside the plant cell where it performs its function, which it seems to contradict itself. It generated doubts regarding the extent of infringements of some such claims. And also to the extent of if this would be applicable only to elite event or even to anyone, to any DNA claim, because at the end of the day, basically what the PTO was stating is that if the DNA was inserted in the plant or animal genome, it would become part of this organism and then not be eligible to patentability. So in view of these questions, many associations reached out to the PTO requesting suspension of these technical notes and the issue of a public consultation so that all the users of the system could provide input regarding these and many other issues that were raised on these technical notes. So in June 2022, the PTO issued a public consultation providing the users of the system an opportunity to provide comments and arguments regarding all these rules. So two main points, obviously many points were discussed regarding several provisions, but mostly for the matter we are discussing today, main points was an exceptional rule according to the Brazilian legal case law can only be applied narrowly, so it should not be interpreted broadly since it's already an exception. And second, since the PTO itself performed a combined reading between Articles 10 and 18, when we do that, we see that it's not only even if isolated therefrom, there are differences. There are many other differences, which show that the Brazilian legislator, when decided to exclude naturally occurring matter, was much broader, using much more language, including biological material, genome, and germplasm, that the Brazilian legislator did not use when drafting Article 18. So there is an intention to exclude natural things in Article 10 that did not exist in Article 18. And as a result of the public consultation, the Brazilian PTO finally issued on May of last year an updated technical note, also called Technical Note 1 of 2023, wherein it basically acknowledges these main points that since it's an exceptional rule, which cannot be broadly interpreted, and also that these matter that Article 18 does not mention, that are mentioned in 10, should be eligible to patentability as long as they are not excluded by Article 10. So if they are not natural, which is what Article 10 is directed to, then Article 18 does not apply. So the main development here is that a plant genome is mentioned in Article 10. So what the PTO is correctly interpreting is that a plant genome that is not natural is eligible to patentability, as well as, for instance, a DNA molecule that is integrated in a plant genome, and so on. So in the technical note itself, the PTO provides examples of subject matter of claim language that is deemed eligible, which is here for you to see. And as a result, we started to, on the last 18 months, we started seeing patents being issued by the PTO with such language. Of course, because of other rules regarding amendments after request for examination, I will briefly talk about them next. Many applications could not redraft their claims during examination, but the ones that had support were granted with claims that already recite either plant chromosome or genomic DNA or plant genome and so on. And what's even more relevant here is that these claims are enforceable against both, against basically any use of commercial use of the plant, including crop products. So as a result, basically, we now have in Brazil, a framework for protection of transgenic plants, not limited here exclusively to elite events, but it's now clear what is eligible in Brazil, what are the limits of the eligibility exemptions, and the plant genome or genomic DNA are the main embodiments to be claimed in these inventions. When we saw that, we also understood that since the provisions of Article 18 are not applicable to non-naturally occurring genomes, then basically it's already providing the PTO's rules a clear guideline to how gene-edited plants can be protected. So the genome of gene-edited plants that is different from those of natural occurrence, and obviously keep in mind that there must be clear evidence according to the PTO's rules that such matter would occur in nature in order to raise an objection regarding a naturally occurring genome, can now also be protected in view of these rules. So here we have examples of summarized claim sets that we would propose for both applications dealing with transgenic plants or gene-edited plants that are eligible under the PTO's rules. So I'll briefly talk about how to best use this to obtain protection for your inventions in view of a few pitfalls that may be found during examination before the Brazilian PTO. The first one is that under the PTO's rules, the request for examination is basically deemed to be a waiver of unclaimed matter or unclaimed language. So under the PTO's rules, if the examination is requested for, let's say, a plant claim, you will not be allowed to redraft to a plant genome under examination. So it's very important to perform voluntary amendments to adapt the claims to the Brazilian practice so that examination is requested for eligible both subject matter and claim language. There are also very strict rules regarding the breadth of the claims, both in terms of claim language and the extrapolation that the PTO allows in view of experimental results contained in the application as filed. And I'll also briefly talk about some rules regarding administrative appeals. So in view, this is the main things to keep in mind to obtain optimal protection for your inventions. So as I mentioned, the request for examinations, first key point to keep in mind, so it's very, very important to make sure that examination is requested within the legal deadline of 36 months from filing for a set of claims that is already adapted to Brazilian practice. When we move to the examination procedure, nowadays, as many of you may know, the PTO has issues. The first action by the PTO is the issue of a preliminary office action, which is an invitation by the PTO for the applicant to submit claim amendments or comments addressing prior art cited against corresponding applications in other jurisdictions. This the PTO does before performing substantive examination. So only based on the response to this preliminary off-section, then the examiner will perform substantive examination. Usually you will receive a first off-section, and any objection that is not fully overcome in this first off-section can already be basis for issuance of a rejection decision. It's possible that a second or even a third off-section are issued, but you should not rely on that. So it's very important to address all objections issued on an off-section to avoid receiving a rejection decision. However, if a rejection decision is issued, an administrative appeal is still available to bring the application to the PTO's appellate examiners. Under the administrative appeal, the examiners can also issue an off-section or final decision. And all this is important to bear in mind that the courts are fully competent to revert any of the PTO's decisions in its entirety. So the relevant new rules for administrative appeals is that the scope of the appeal has been narrowed. It used to be the case that the appeal was basically a new off-section being issued, and the applicant was allowed to argue whatever way applicant wanted during appeal and amend the claims, as long as limited to the claims on file when the examination was requested. Under these new rules, the appeal is limited to the specific objections contained in the rejection decision. Applicant is no longer allowed to limit the claims based on the specification, basically only limiting independent claims based on dependent claims. And also, if applicant has failed to comply with a requirement by an examiner during examination, then it would not be allowed to afterwards go ahead and comply. So it's very important to keep in mind these when performing examination before the Brazilian PTO. Finally, the division of practice in Brazil is also somewhat unique. The PTO's rules generally treats divisionals as a way to obtain protection to pursue subject matter that is deemed to lack units of invention, but not as a way to have a new round of examination. So a divisional that is filed with claiming the same subject matter may be outright rejected and not be useful for having new opinions and submitting new arguments for pursuing the same subject matter. So even more important to make sure to address all objections, submit auxiliary requests, trying to overcome all objections as a fallback, because applicant may be prevented to do so moving forward. So here is a brief list of do's and don'ts of what to do during prosecution of patent applications in Brazil to make sure that you have optimal protection. As I mentioned, reviewing claims before and adapting to local practice before requesting examination to make sure that they are drafted in legible claim language. Having experimental evidence to comply with the sufficient disclosure requirements and rules of the PTO. Here, whereas ideally it could be present in the application as filed, it's also possible to submit post-filing data. So if from one side, the examination may take more time in Brazil, you should definitely take this time to produce experimental results showing that the commercial product has the technical effect of the invention, so that any limitations that the examiners require during examination, you can do not exclude the commercial product. And finally, submitting auxiliary requests and dependent claims during examination to avoid losing the rights to further restricting the claims moving forward. And what not to do would be basically requesting examination without complying with the PTO's practice, rely on a single experimental result that is not the commercial product, submitting general response to an officer action without addressing each objection of the examiner, and not submitting auxiliary requests and dependent claims that would fully comply with examiner's requirements. And also rely on divisionals as a new round of examination, which may not be available. Finally, on a different subject, I understand that several inventions dealing with agricultural compositions are also relevant. You should keep in mind that under the PTO's rules, a composition that is defined in a claim as a comprising a single component is deemed to cover the component itself, and if the component occurs in nature, then an objection under Article 18 would be expected. The PTO's rules even go beyond that and consider that mere dilution of a non-eligible component would still be excluded from patentability. So this makes it very important to have support on the application as filed to limit such claims, adding restrictions such as additional components that are not natural, so as to overcome an objection under Article 10, whereas still covering the commercial product. Another point is that coated seeds are deemed to be compositions. So this means that Article 18 does not apply, so it's not a plant part because it has more than one element, which at least one of these elements is not a plant part, so it's a composition. So basically the composition provisions apply here, not the provisions of Article 18. And if as I mentioned, the active ingredient of a composition is biological, even more important to have support on the application as filed for additional components that would allow a restriction of the claim to exclude the naturally occurring subject matter while still covering the commercial embodiments. So this is the subject matter that I had to share with you today. Thank you so much for attending to this, and Pedro and I are here to answer any questions that you have. Thank you.
Answer anything else?
Yeah, I can see an event question. Kelly's question is asking whether inventive step rejections in view of prior art, where the trait has been previously expressed. So what the technical notes in force provides is that an event would have to have an unexpected effect. So basically the PTO's position is that, for instance, if the prior art discloses that a certain protein is able to confer herbicide resistance, and the only experimental results, the effect of disclosing an event application is herbicide resistance, then it would lack inventive step because it would be expected. But the unexpected effect can be N. So if the herbicidal resistance is increased in the event from what would be expected from the prior art, then the PTO will request experimental data comparing one with the other to show such effect. Or the effect may even be very different. So it may, although the transgene is for herbicide resistance, the effect may due to several factors, may be with regard to other traits of the plant, so production of protein seeds or yield of the plants and so on. So this can also be an unexpected effect that would provide inventive activity.